online and with us. May I?
Yes, Vinay, I have joined.
Yeah, thank you. I request Dr. Sudhir Verma, Assistant Professor VIT, AP University, to join us. Ms. Priyansa Badoni, and I request to join this session. Now I hand over this session to Chair on.
Thank you, Vinay Kumarji. Friends, this is the last session of the day. After hectic session, the previous session, I think most of the audience have left, but I hope they will join. So he was provided here also. I hope people will. Okay. Friends, we have 1 hour's time. This session is about international law, teaching and research in India. The theme of this session is excellent, wonderful, because we come from the university system where the teaching and research is the main function of researchers and teachers. These days we are, living in the age where WhatsApp University is very famous. I am very happy that we have the real university teachers here who will be deliberating on very important themes like why should international law be taught, how to disseminate international humanitarian law. These are the areas where we are going to discuss today. Since only 1 hour is with us and 5 panelists are there, I think we have to ration the time available to us. I think around 15 minutes is the maximum and 10 minutes is the minimum. Those who can complete in 10 minutes will get the first rank award, something like that. Because I remember in one of the seminars in Aligarh Muslim University, one teacher was presenting and having a script of 50 pages from history department. Probably he had done MA in entire history or complete history. Among the audience, all were getting bored. History is sometimes boring also. One person from the audience slowly came near the podium and took away his paper, 50-page paper. The teacher was helpless. So that is why that kind of situation should not arise here. I hope our panelists will be like diplomat, try to finish in 10 minutes time. Our first speaker I call Major General Narendra Kumarji, who is Executive President of ISIL, to make his presentation on dissemination of international humanitarian law. He is going to make some suggestions. Thank you.
Can you hear me at the back, please?
Yes,
sir. Okay. The chair, 4 panelists here, and the delegates for this conference. In the short time assigned to me, I would try and cover about dissemination of international humanitarian law in India. At the outset, I would like you to appreciate that although India gained its independence by peaceful means and we relied on propagated peaceful coexistence, but right from its independence, we were drawn into armed conflict. Now, starting from 47, 48, the border war with Pakistan, thereafter getting into Goa, that also was by the use of military, followed by the Chinese aggression, 65 war, 71 Bangladesh, and right up to Kargil and recently Galwan. So, despite all our emphasis on peaceful means, we were drawn into these conflicts, and these wars that I talk about had sizable number of casualties, both combatants and civilians, killed, wounded and taken prisoners. And therefore, it is in these situations that the provisions of international humanitarian law, they squarely come into operation. Because IHL accepts that wars are inevitable, wars cannot be outlawed, but what needs to be done is that those who are not taking part in the combat, or those who are rendered incapable of taking part, they need to be protected. And the four Geneva Conventions of 1949 and subsequently the two additional protocols, subsequent instruments, they all are designed, targeted at this end. You are also aware that India took a leading part in the framing, designing of Geneva Conventions very promptly. By 1960, they had been transported into our domestic law, and the Geneva Conventions Act was passed. Despite that, and despite India having got almost a lack of prisoners during the 71 war, the actual literature about the compliance, about the dissemination, about enforcement and adherence to IHL in India is not satisfactory. With all my efforts, I could find only one book dealing about what was the state of prisoners of war in 71, and that was also the entire sort of coverage was done in a superficial manner without any actual serious depiction of the lessons that have been brought out. Because when there were more than 91,000 prisoners, there must surely have been instances of escape, defiance of authority, some administrative actions taken, complaints, etc. Well, there is no knowledge in public domain, and perhaps the records of the Ministry of Defence are yet to be declassified. Be that as it may, we have a situation that dissemination of IHL is enshrined in the Geneva Conventions itself and also in the additional protocol, Article 47 of First Convention, 48 of Second Convention, 127 of Third Convention and 144 of the Fourth Convention. These are particularly directed at dissemination. Now, what's the importance of dissemination? You've got to know law to observe the law, and then only if you know the law, the compliance would come in. At this stage, you also got to understand that IHL relates to international humanitarian law, as we say, which comes into operation in armed conflict situations. And these situations may either be international armed conflict or sometimes non-international armed conflict. But in most of these situations, it would be the armed forces personnel who would be accused or would be in a position, to say the least, to commit the breaches or grave breaches of the Geneva Convention. A normal civilian who is away from the battlefield situation, he would never be accused of having committed a breach or a grave breach. Most of the time it would be the people in the armed forces, and therefore there is a need that armed forces personnel need to be taught about the IHL. Also, because of the element of the command responsibility, where a commander may be divested of his responsibility with regard to a particular crime that has been committed if he can successfully show that what had been done was at a far away place or at a situation where he was rendered incapable of enforcing control. Short of those situations, a commander would always be responsible for the actions taken by his subordinates. But those situations also come in. You would have read these days that the atrocities, the war crimes, the horrendous violence acts that you read every day about situation in Ukraine. And therefore, this topic of dissemination is very relevant to our context. And it is not only the armed forces personnel, there are others who are not in uniform, the civilians, they also need to be taught about this for the simple reason that it is one of the law passed by the parliament. There may be people who are lawmakers, there may be those who are with the media, they are concerned about this law and therefore the teaching does take place. Now, my experience, and I shared this information, I got this from the regional delegation of the ICRC. Unfortunately, they did not have precise information how many universities in India have IHL either as a compulsory paper or as an optional or elective paper. Nevertheless, this subject is being taught in a number of law schools and colleges. I found that Bhopal, the National Law School at Bhopal, they have designed a syllabus for teaching this of say a 2-credit course for the undergraduate students. That's fairly okay, that should suffice. But what is the problem, what's the main difficulty is absence of literature in this regard. And this problem is compounded by the complex language used in the Geneva Conventions. The conventions are framed in a language which a normal law practitioner may not find it easy to understand. Just for your information, to highlight this point, I jotted down a few words like plenipotentiaries, amelioration, high parties, international characters, hostile combat, outages, judicial guarantees, carrying out of execution, dictates of public conscience, neutral power, chaplains, sufficient assurances, and so on. The point I am trying to make is that these words, this language is not usually found in the legal text, and therefore it is to that extent difficult, it is technical to understand. And also this needs to be appreciated that these conventions of 49, they were framed in Geneva after the Second World War, where the main participants were the European powers. So the examples that were taken, or the examples which were in their mind which when they framed these conventions, were not similar to situation in South Asia. And whereas more conflicts now take place in our part of the world than elsewhere if you leave apart the Ukraine war. And therefore, there is a need that Indian version and Indian commentary of these conventions and protocol, etc., need to be brought out. This has not been done so far. There is one institute in San Remo that was set up, say, 4 decades back, and India having one of the largest army in the world, one of the largest users of armament, does not have a training institute of that size. And therefore, this subject needs to be taught in a clinical manner, because a pure academic discourse on Geneva Conventions may be very difficult for the students to grasp. And hence a need that the trade, the situation-based combat pamphlets, presses, etc., need to be published in simple language, maybe in vernacular, so that the students understand the situation why protection is important to the four category of people, whether they are sick and wounded relating to falling under Convention 1 or those who are shipwrecked, taken prisoners or in the occupied territory. And therefore, this responsibility of preparing literature, well, I had to bring out a book because I found that whenever I was called upon to teach this subject within the army or outside, that paucity of literature made it difficult. And there were situations painted in two warring factions, that this is what is happening, and you have to apply your mind whether a convention is breached, whether it is in accordance with the convention, whether it is allowed or not allowed. And therefore, my point relating to teaching here of the Geneva Conventions and the IHL to the two category of audience. One is the military and second is non-military. To both we need to prepare the literature to teach this subject, which presently is not available. Now, this teaching in a clinical manner cannot be undertaken in the desired manner by the Socratic method or by the lectures. And therefore, what is needed is that you give assignment to the students, hold mock trials, have situations painted, slides, and project assignment to the students where a particular lesson with regard to, say for example, a soldier who is wishing to surrender, how is he expected to be treated, or with regard to the breach of emblem and so on. And I found that the approach where these exercises, when they were designed and they were issued to the students, and the students were distributed in small syndicates of 4, 6, 8 students, and they were called upon to respond to that as to how they thought that situation would be dealt, would be covered, and what provisions of IHL would be applicable. Well, they found it interesting, absorbing, and it brought home, succeeded in bringing home the suitable lessons. I would also suggest that the law schools should introduce the IHL subject in a manner, which could be a 2 or 3 credit course, where profitable use can be made of the practitioners who come and who explain. Help can be taken from the regional delegation of the ICRC, because they are expected under their mandate to provide technical assistance in this regard, and this literature and the instructors, when provided by them, would go a long way in setting up a proper manner teaching of the IHL, both within the military as well as in the schools and law colleges. Well, that is all within the limited time that I would like to tell you. After that, in case there are any questions, I will be happy to take them on. Thank you.
Thank you, Major General Narendra Kumarji. You spoke on a very important theme about how to disseminate IHL among the citizens, because you mentioned that it will lead to better compliance. I appreciated your most of the suggestions. I do not know whether Indian government and Ministry of Defence has prepared any brochure on do's and don'ts for armed personnel in the light of international humanitarian law in all the 22 languages listed in the 8th schedule of the Constitution of India.
Thank you very much. Very interesting question. There is one. At the outset, I would like to tell you that IHL provisions, to a very limited extent, came up before the Supreme Court in the Naga people's case, the 5 judges bench. And there, the Union Ministry of Defence, part of the Union of India, which was the respondent, and incidentally this provisions of the AFSPA It was not a strictly IHL situation. We view it as a human rights situation, as a law enforcement. There, the Assam government was against the union in that matter. So Justice J.S. Verma, who wrote the judgment, he touched upon this do's and don'ts. Now you said all 22. So firstly I would say that the only literature which we were able to produce was that 2 pages do's and don'ts, number one. Number two, it was in English and Hindi. Well, not in 22 languages, because the soldiers in army, they are taught the words of command or the official language to deal with them, irrespective of what their home language has been as Hindi. We can't have officers knowing 22 different languages to command that troop. So that was there. Now that is grossly inadequate. We need to have literature depicting based on situations in South Asian conflict. That's the point I made. Because the Geneva Conventions, even if you look at the commentary of Geneva Conventions, and additional protocols is based on situation in Europe during the war there. So I would restrict there, stop there.
Thank you. Thank you. Actually, all the questions have to be taken up at the end. I just raised this question. Now I call the next panelist, Professor Monica Chawla. I think she's online. He will be
Thank you.
at the end.
Thank you, Mr. Chairperson, for giving me an opportunity to present my paper. I have not been able to reach out to Delhi because of some departmental schedule. So we're having the counseling, so we couldn't actually make it to Delhi. The admission process is going on. So my paper actually, it is on the topic of teaching of private international law. Now, teaching of international, it's very much confined to what is the perspective of international law being taught in the universities, in the national law schools, and whether private international law is being taught in any proper sense in any of the universities or in the traditional universities. Now, if we look at it, the teaching of the international law in the Indian system, it remains a little laid back. But it is, though international law is a very, it is a compulsory subject which is being taught in the universities as per the guidelines of the Bar Council of India. But beyond that, the students do not show much interest in taking international law. It tends to be the last choice of the students in the traditional universities. The reason may be because maybe the students are more attracted to the corporate law courses depending upon the markets, so they would like to take up more courses on business laws or criminal law, constitutional law. But when we come up with any kind of a course like LLM in international law, we do not find many students who opt for it. So this scenario tends to exist in most of the universities in many states. And if you look at the teaching of international law and the master's courses, you find it would be more towards the metropolitan cities rather than towards the interiors. But if you look at the importance of international law in the present perspective, it has attained great heights because people have migrated from India to many countries all over the world. And whenever a person migrates from one country to another, he carries with him his own personal law. So we need to know what is private international law. Actually, private international law, it is a law with a wide range of, it covers a wide range of subjects like including law of contract, torts, family issues, and child adoption and abduction. So whenever issues like these emerge, private international law tends to come into picture. So as we know that each person from the country of origin carries his own personal law with him. So even in other countries, even in other countries, any issue relating to personal or country rights, if it is to be resolved, it is under the private international law. Now, private international law deals in deciding the local or foreign laws to be applied to cases involving private legal relationships and existence of foreign content, that is choice of law. So private international law aims to bring order and predictability to cross-border legal matters, fostering fairness and consistency. Its scope covers a wide range of areas such as contracts, disputes, family law, property rights. Private international is also called as conflict of laws, and as the existence worldwide of and within individual countries of different legal traditions, different specific rules of private law and different systems of private law, all of which are administered by the court system similarly subject to the different rules. There are very few institutions where private international law is taught as a subject. And if we look at it, we find that the Indian Society, we are lucky that Indian Society of International Law, the teaching wing of ISIL, which was founded in the year 1964, the objective of which has been dissemination of knowledge of international law, has a postgraduate diploma course in private international law. Otherwise, you will find that private international law is just an optional subject in many of the bachelor's courses of law. But still, the question remains that most of the universities, only a handful of the universities are offering this subject as an option also. So, since LLM in private international law is very confined to certain universities, so we find that the teachers to teach the subject, which is a mandatory requirement by the Bar Council, we find there are very few teachers on this particular subject. So the major challenge which we find is that we do not have very good teachers who can teach this, since we do not have students opting for it. So the people are made aware of importance. Many times the students are in a dilemma about what would be important, why should they take up international law? So what is the reason for which they should opt for this particular course? Because they do not find much of relevance in the day-to-day life. But one should be aware that with so much of immigration and people going around in other countries, the importance of private international law is increasing day by day. But this subject needs to still catch on with the students, and they need to show more interest in this particular subject. Because if I have to look into the curriculum or the syllabus which has been formulated for this particular subject, it is much related with the family law kinds. So the domicile part, it relates to marriage, divorce, succession, adoption, etc. So any element any case which has a foreign element involved in it, it tends to be resolved under this. It will tend to fall under this. So the need for having the application of international law in the domestic law, in the municipal law, is taking momentum, catching momentum day by day. Because if in case of marriage, even the judges, civil judges of the district courts and other courts, they are bound to accept that this domestic law, somewhere municipal law will have a certain element of application of international law in many of the cases. Why we find in Mirja Sarafa case and many other cases in which the courts have actually decided the issues relating to this matter. So with this, I do not take much time. I only stress that we need to actually lay more emphasis, more awareness among the students, that they should opt for the subject so that this subject does not just dialogue with it. Private, I'm talking about private. International law, though international law is a very vast field. But under international law, there are two laws: public international law, private. Private international law is not having much of. There aren't many students and teachers who are available in this field. So we need to lay more emphasis on how this subject can be further enhanced and further brought up in the system. Thank you.
Thank you, Professor Monica Kawaji. You highlighted the importance of teaching private international law in this age of globalization. Thank you very much. Now I call upon my next speaker, Dr. Sudhir Vermaji, who is Assistant Professor at VIT Andhra Pradesh, to speak on a need for teaching critical international legal theories in India.
Thank you so much, Chair. It is a moment of great difficulty for me, to be very honest, to present in front of my own professor, Professor Hegde. I owe a lot of my learnings to my MPhil coursework at JNU under the guidance of Professor Chimney, Professor Desai and Professor Hegde in this particular lecture. My exposure to critical legal studies dates back to when I entered JNU. A distinct way of thinking international law which I have never came across before. I'm sorry, I'm under weather, I'm sorry. My main ideas with respect to this presentation came up as part of my teaching experience at VIT AP School of Law and NLU Delhi, the subject critical international legal theories. What I would like to start with is that students in India, the law students in India, are so much obsessed with mainstream theories that they tend to not think critically. When I say they are too much obsessed with positivism, with legal realism, with other mainstream theories, I mean to say that they believe that law has to be neutral, that law has to be objective, which I would like to refute, especially in the learning phases of students. This particular presentation may not be that much effective when it comes to practice, but it definitely augurs and augments the practice of practitioners as well. So theory augments practice. My presentation starts with an excerpt from the book of Professor Roberto Unger, who's one of the propounder of critical legal studies, and he writes, when we came, critical legal studies in 1970s, when we came, they, the positivists or traditionalists, were like a priesthood that had lost their faith and kept their jobs, the jobs of international lawyers. They stood in tedious embarrassment before cold altars when international law was attacked badly. But we turned away from these altars and found the mind's opportunity in heart's revenge. It means to say that we started to find international law somewhere else. And that's really where the thinking process of students need to be inculcated. So by basic premise, students must be compelled to not do international law, but think international law. This particular theoretical framework, or I could say theoretical regime, is predominantly academic in character, and it composes of radical critique of academic and intellectual establishments. My presentation is divided into 10 subheadings. If I may be able to complete, I would cut it down to 5 maybe. First is considering law as politics. Number 2, highlighting a brief on indeterminacy theory or thesis by Marticus Kenmi. Third, the highlights of the knowledge, the importance of knowledge is laid down by Max Horkheimer. Fourth, dealing with French post-structuralists and the lessons which we can teach to our students, especially from the theories of deconstruction by Derrida and Michael Foucault's discursive analysis, the discourse analysis. Fifth, critiquing the way law is taught. I'll take it as the first point now. Sixth, Mark Kelsman's understanding of trashing the formal international law. Seventh, critiquing hagiographic reconstruction of history. Hagiographic meaning a history served to address a particular political agenda. These are the times we are living in. Rhetorics. Eighth, structuralism. Ninth, postmodernism. And 10th, new stream approaches to international law pioneered by Professor David Kennedy. So, as I promised, I would first move on to my fifth point, that is, the critique should not just be of law or case law, but also in the way international law is taught in most law schools most of the time, drawing my inspiration from the book of Professor Louis Henke. Law students are made to internalize legal reasoning as the only analytical tool through which law emerges, which is wrong. They are taught to normalize hierarchies as one of the ways of succeeding, that is, to show appropriate forum of deference to those above you and condescension for those below you, a sort of a patronizing element. These spirals of patronizations gets mirrored in professional and social hierarchies, which we see even today. We witness it every time. I call them perpetual chains of bondages from which we must free our pupil to help them see more clearly the relations of power and knowledge. They must be encouraged to look beyond and imagine new ways of keeping an ultimate end of social justice as a backdrop. They must not be compelled to think formally, think universally, think neutrally, or think impersonally. They must not be compelled or taught to eclipse their own selves. They must be taught to be free. There is a need to acknowledge the political and ideological character of international law making and resisting it. That is my first point. Second point, law is politics. Law is politics. My first premise, again, quoting and unquoting Professor Andrea Bianchi from his own book, International Law Theories. International law does not exist in international vacuums, and that is what is the politics behind the making, implementing, and acknowledgement of law, and which we need to unmask and unveil and reveal for our students. If we are not able to do that, at least we must develop a culture where they can think on their own. There is a need to critique the objectivity and neutrality of law. International law do not exist in international vacuum. There is a need to unmask assumptions and presuppositions that may be moral presupposition, epistemological presupposition, and empirical presuppositions. And mind you, these propositions often lead to conservatism in society. Most of the time, legal claims aim to advance the interests of some identifiable political grouping. The mainstream find it hard to believe that politics is no external paraphernalia. I believe that it is internal to the law. Second, indeterminacy thesis. Indeterminacy thesis argues that liberal legal system is inherently flawed. I mean, it's a strong point to make. However, they have their own defenses. Of course, it is again marred with criticism. According to liberal, that's what they say, the indeterminacy thesis people, they say that according to liberals, rules can solve disputes if applied in a rational, necessary, and objective manner. Indeterminacy thesis highlights that rules themselves are indeterminate, and so are the results of application of those laws. And so, therefore, according to Marty Kuskianemi and David Kennedy in their recent book, they have written a very strong point and premise that it's other way around. Rather than society shaping law, law must be able to shape social actions. The third point, Max Horkheimer on knowledge. He opposes the idea that knowledge is the mirror of nature, that it can be apprehended objectively by the intellect. According to him, so he basically deconstructs the application of knowledge, and he says, according to him, knowledge is in the end historically and sociologically determined, which keeps on changing. Some knowledge you have a point of time behind, you might have some other knowledge in future. And this was very well highlighted by Professor ICJ Judge Kankado in a lot of his advisory opinions when he talked about the time and its linear and cyclical application in the making of international law. Knowledge is, so he says that knowledge is in and of itself historically and socially determined. Knowledge should be taken to be functional to social action, and can work as an emancipatory tool for the transformation of society by transforming constant social actions. Critical legal studies is a way of criticizing the rationality of social systems against the background of an ideal of social justice. Critical legal studies aim at unmasking the rationalization of social injustices. Behind every social injustice, there is some sort of a rationalization. For example, white man's bird. So we need to unmask them to understand the linkage between power and international law, and this must be taught to our pupils. Fourth point, French post-structuralists. They have an aversion to grand theories. They don't want to be called this. They don't want to be named as ists or isms or something like that. They attempt to unmask truth claims as concealing hidden assumptions and vested interests. They stress on the role of language to shape and comprehend reality. Derrida's reconstruction that held out of textual criticism with a view to unmasking the underlying presuppositions of the text is one such example. Foucault's innovative traditional epistemological approach of focusing on the genealogy of knowledge is another example. Quoting and unquoting Foucault now, what may appear as rational or scientifically sound and necessary truth in modern society are in fact contingent products of historical and social forces, he says. Well as society's commitments to particular ethical and political values being manifested in those historical and social forces, he says. There is a need to expose both these historical and social forces behind the making of knowledge and law, along with understanding the ethics and political values that interpret such laws. Thus, Foucault exposed the relationship between the production of knowledge and power structure, which he termed it himself as doing something called discursive analysis. It is an important point to be noted that discursive analysis can be very important in understanding international law's perspective on sexuality, racialism, gender and discrimination, taking from Ann Peters' work. Foucault can be invoked to understand these social constructions, and Foucault's one last concept of biopower is another important thing which students must be exposed to, at least the methodology, which means exercise of control by modern states over people's bodies, which allows them to control and subjugate entire populations. By making use of technology, states intervene in people's lives, claiming regulatory powers over aspects of individuals' lives and health. We know it right now what kind of data revolution we are living in. This answers all sorts of patriarchy within an international society and even domestic. Point number 6, I've already dealt with. Point number 6, Mark Kelsman's understanding of trashing. Chair, how much time?
2 minutes you can mic up.
Yes. Mark Kelsman's idea of trashing. That this particular was the title of a research paper which was published by him as Trashing in Stanford Law Review. He says that there is a sense of awe that professors so often inspires, as they represent keepers of great secrets or priests with access to privileged thoughts. Similarly, like Marxist concepts of alienation, of fetishism. This is often achieved by creating a technical fog to obscure true concerns to make the peoples bow, scrap and believe themselves to be deeply unfit and inferior. Kellnan calls it illusory hierarchical illegitimacy. Thus, he demonstrates phoniness of hierarchy, ingenuineness of hierarchy. These shackles of hierarchy need to be broken. I like the Western conception of calling professors by name. I'm sorry, I'm speaking in India. Point number 7. There is a need to critique hagiographic reconstructions of the history of the discipline. This comes from Marty Koskenimy's work, where he says that there is a political agenda of depicting one sort of history of international law. So it is the histories of the history of international law, the paper, There is a need for the students to read critical theory, structuralism, literary criticism, post-structuralism and post-modernism along with the discipline of international law and law generally. There's a need to be aware of the risk of false consciousness and false necessity, which makes reality appears normal and inevitable, while at the same time concealing the deeper structures of divisiveness in society as well as legal relations. And I would wind up with my last point on structuralism from the work of Ferdinand de Saussure. He says that the language constitutes a system. I'm explaining structuralism, through which I will explain the critique of international law, formal international law. So he says that the language constitutes a system whose signs distinguishable between the signifier and the signified develop, intercommunicate and are imposed on their users based on law independent of their will. Basically, short point, the way the law is made, the way the law is implemented is completely, the manner in which it is done is completely alienated from the society on which it is imposed. Basically, when you don't know the dynamics of the making of law, you actually cannot question or critique that law. You will have a sense of a normalization of such an international law. The structure of a system is taken as stable, of course, universal and ahistorical. What is happening is today, right now. We are not getting into historical deconstructions. This is what is argued by mainstream. We all know that law is a command of sovereign according to mainstream. Do not get into moral values, do not get into social milieus, do not get into history. Just focus on law as it is, make it as reductive as possible so that you can have predictable results. Indeterminacy theory argues that international law's main aim is never predictability. It never wants to even go for predictability. Next, Claude Lévi-Strauss, structuralist only, suggested that by penetrating into these unconscious structures of language and making of international law, it is feasible to formulate principles of interpretation of series of human practices. Once you are able to understand human action or social action or human practices because of law, you will be able to engineer them as well. Now I'm focusing a part of my thesis on structuralism and part of my work on a part of my statement on Weber's idea of capitalistic society and law. I know that I'm doing that intellectual eclecticism. I know that, but still it is relevant. And anyway, David Kennedy again in his new book he says that we are living in a PDM era. That is, we are living in an era where modernism and postmodernism go hand in hand. Some methodology applied, the structuralism methodology applied in international law, which are basically used by a lot of writers, along with my own professor, Professor Chinni in his book World Order, is for philosophy, they refer to Foucault. For social sciences, they refer to Althusser. For sociology, they refer to Pierre Bourdieu. For Freudian psychoanalysis, they refer to Jacques Lacan. For psychology, they refer to John Piaget. For literary theory and criticism, they refer to Roland Barthes and Jacques Derrida. For applied sciences, they refer to Thomas Kuhn's, architecture, Le Corbusier, economic IR theories and international theories. I can name you a lot of scholars like Mark Tushnet, Robert Unger, David Duncan Kennedy, etc. But one point I would end with that particular point by Roland Barthes that is important, is that structuralism tracks collective praxis and dialectical relationship between the human and its physical social environment. It says that structural understanding, a correct understanding of structuralism will help you understand where the law comes from and until its application on the ultimate agency. This way you will be able to deconstruct law better. This element of structuralism has been used by critical legal studies a lot. This leads to an end of paradox. That is a third discourse. That is, you get to know the third discourse, which is between reality and imagination. This reality and imagination needs to be exposed so that our students have clear-cut idea of how the things are going about. Working on the work of Roland Barthes, there was a theory which was proposed in Latin America titled as a neo-Marxist Latin American dependency school, which is also called Dependencia, was propounded in 1945 and 1970, theorized by Samir Amin and Emmanuel Willerstein. They called structuralism as asymmetric structuralism. They called structuralism as asymmetric structuralism, saying that it is only based on the center and do not take care of the periphery or the developing nations. What all dynamics of making of international law they are talking about from a structural perspective is only that of the core, not of the periphery. And this is where there was a major structuralist backdrop, and where postmodernism and post-structuralism came in. And I would wind up by just stating the stated aims of new stream approaches of international law by David Kennedy, which says that international law can be divided into three, that is sources, procedure and substance. And all these three have a binary. One is, in sources it has hard law and soft law, procedures it has participation and jurisdiction, and substances it has sovereign autonomy and community sharing. And he says that it is these binary, according to new stream approaches to international law, these binaries are doomed to coexist and be rhetorically blended, always, making the boundaries porous, calling them dialectics of binary. David Kennedy calls it interminability of international law, as there can't be any final word in the discourse, is the key to its success. So what we need to teach our students is that the appreciation of the success of international law lies in its indeterminacy and interminability, and not in objectivity and neutrality. Thank you.
Thank you, Jil Vermaji. Now I request Priyansha Badoni, doctoral student from Jamia Millia Islamia, to make her presentation on impact of digital legal research on its stakeholders in assessment. Please stick to 10 minutes time. Yeah. We have one more person.
Hello. Yeah. Hopefully I take much lesser time. Good afternoon, all everybody present here, respected chairpersons and my co-panelists. I am very fortunate to share the panel with such senior professors, but I am equally very nervous. I was a student of ISIL in 2015. I'm very happy to see Dr. Vinay and Dr. Luther Rangrezi here, who have been my teachers. I'm currently pursuing my PhD in investor-state arbitration. However, I have varied areas where I'm interested, which includes pedagogy and the domain of research itself. And especially, I like to study the impact of technology in various aspects of our life. Particularly, I'm speaking about academics here. So when I say stakeholders, there are certain stakeholders that I've identified, and I mean the persons who are contributing and are also consumers of legal research, right? So before that, I came across a very interesting quotation by Frederick C. Hicks in an American university. He is serving as Dean of Law Librarians, who one has not truly found the law until one understands it. And this requires the knowledge of substantive law, which comes only with passage of time and much experience. So, my main premise that I'm working upon is that how using digital facilities in conducting legal research is actually compromising on the quality of output that we are giving. Because law as such requires time to be mastered. Technology, as we are aware, is revolutionizing every aspect of our life, and academics too does not remain untouched by this. Research is an essential activity for any field of study, and technology has in fact brought immense changes in the same. Legal research, which was earlier predominated by printed material, now we have made a swift change to digital resources. There's a change in how information is being processed, discussed, analyzed, stored, and this is leading to certain problems. Now my research questions, actually this is a study that I would further like to take horizontally. In this particular presentation, whatever I've researched, there has been a vertical, a research plus observations. So have these technologically facilitated changes eased the understanding of law, or it has further complicated it for you? Alright, one example being that when you're looking for any information online, there's plethora of information and you do not know which is the authentic one and which is, you know, the one that you should be actually using. There is no doubt that technology has made conducting legal research faster and cheaper, but hasn't made this pursuit and the outcome any better. And with the changes in modalities of conducting legal research, will the discipline of law change itself? Yeah, the research questions have not been formed in a proper fashion how they should be, but I'll work upon them. Now, what were the hardships in our old method? When I say old method, I'm focusing upon when you're using printed material. Of course, it was time-taking. You were referring to a lot of resources to arrive at a conclusion or to further your research. The material themselves occupied space. Now, when I space, I'm speaking about infrastructure. I'm aware of a lawyer I used to intern with, who in fact, you know, had rented go-downs to put his books. Printed text became redundant. Now, if any new law is introduced, you know that your textbook has already become old, even if you have purchased it a few months back. And of course, the hassle that is involved in navigating old material. The stakeholders that I've identified here, and I'll quickly go through them, are students. Most of the audience present here comprises of students, researchers, where I'm considering both researchers who are engaged in academic pursuit and professional researchers, law teachers, advocates, judges, librarians who are very important you know, in this particular domain, and publishers. Alright? So, what is the impact of technology on student researchers? Students are major consumers of research. But you know, the fashion in which they are conducting research, or what our teachers popularly call the CCP approach, cut, copy, paste, it is not helping them anywhere in learning anything. At least, you know, in the older days when the research was conducted through printed material, you were hopeful they will sit in the library for some time, navigate through certain material, and get something, you know, produce something out of it, get some idea, their mind will start thinking. So what we are seeing now, they are able to put forward any fresh ideas. You know, the teachers themselves are hardly reading their projects because, of course, there's nothing new which is being produced. And now their role has become very limited to being carriers of digital information. It is restricted to that. They are not taking time to process the information that they receive. Doctoral researchers and professionals, I've used the term that they are suffering from infobesity and information fatigue. The content which is available to the researchers like us, the authentic or the sophisticated content is not freely available. So, and the freeware such as Wikipedia, you know that you yourself can go and write content on, edit and write content on Wikipedia, so it is not an authentic resource. So what we are seeing in research domain also, because of this, there is a move towards empirical studies. You're not trusting, or the colleges are no more inviting candidates who are ready to pursue doctoral study, because due to the, you know, like I said, infobesity on internet, you want that empirical research is conducted. So you are going on the ground and at least getting something original. You're using many mechanisms to conduct empirical research. That itself is not helpful, because again there's a question regarding these resources need not necessarily be full. For example, I may, you know, earlier we used to go and we prepared a questionnaire and we would meet the persons we want to be respondents in our research, but now you're simply sending, every day you're receiving a WhatsApp forward also as a, this is a questionnaire of my friend pursuing particular research, kindly fill. And of course, you know, nobody is interested, or you know, hardly taking any time without realizing that it is actually an academic activity that you are invited to be a part of. It is very serious, right? So there, this digitization is nowhere helpful. Law teachers, on the other hand, of course, conducting research for them becomes very important for their academic progression. Their work is also to encourage the students to pursue. They can guide their students in pursuing authentic research. I'll cut this short. go to advocates, and I'll take advocates and judges together. Now, advocates as such are also dependent currently on online database. So whatever Manu Patra or SEC Online presents to them as the most suitable precedent, they are going to quote it in the court, right? But there is a problem with that too. When you are quoting a case which you have, extracted in a digital fashion, it is not necessarily that is the most suitable case or a precedent for your particular case. I'll cite a situation and I'll take judges in this category itself. That in 2005, a case got mentioned. I'll mention the case name. It is Sahu Rajeshwar Nath versus Income Tax Officer, Meerut. It's a 1968 case and particularly deals with liability of partnership for payment of taxes. It restricts itself there. But then it goes on to become a precedent in a case which had nothing to do with this particular premise, right? It got cited in a case called Ashutosh versus State of Rajasthan and others in 2005, which was a case related simply to minor partners' liability. Now, if this is going to happen, it is actually creating it is very harmful for us as law researchers or the consumers of law research. But why is this happening? Again, judges also, they have paucity of time. Their job has become far more difficult because they are under pressure to give out judgments very fast. They are published online, so they are available for public scrutiny also. And hence, they are also, judges are also dependent that whatever output or whatever, in fact, arguments that the advocates are making before them, it is, it is reliant on a presentation of a well-structured proceedings. Librarians and how they can be helpful in, controlling the damage that digitization of legal research is causing. They cannot anymore be restricted to their roles as archivists. Librarians' role in the present time has to get reformed, that they help students to navigate through what is the authentic resource and what is the not so preferable or a non-authentic resource. Alright, so they can be helpful in creating, there's an information chaos, we are already aware of this, by performing additional quality check. This is where our librarians can be helpful. Publishers, yeah, I do consider them to be a part of our fraternity, our legal fraternity, because ultimately they are the one who are transferring knowledge from the source, the creators of law, to the consumers ultimately. So their job in the present time has become very difficult with the digital, with the print going redundant, and now they also have to move to digitization. How they can be helpful? Maybe it should be a very fancy imagination that they become responsible and ensure that
or a particular principle of international. Now we talked about, let me start with an example. Arbitral awards. Today we talked about enforcement of arbitral awards. Now I had not in this context, but there was a debate some time ago in some law school where I was part of a discussion. There was a criticism saying that why New York Convention is not defining an arbitral award. There is a definition, but there is a very, very interesting definition, but there is no definition, but there is a reason behind it. Because the people have no time to get into the private preparatories of the New York Convention and to look at why they have not actually defined it. Look at international law. See, for example, there is a whole debate on aggression. There is no definition of aggression even today. There is finally in Kampala they came to some kind of a conclusion, but still there is a whole lot of difficulty in defining aggression. So international law navigates, as Sudhir put it so well, between different kind of things actually. You see, that's the beauty of international law. See, that's the strength of international law. Without knowing these things, I appreciate they are very good students. They take up a lot of very interesting, very cutting edge research in areas, and then they do it excellently. They collect materials, of course, online. There I'll come to it in a short while. And then, because of lack of basic understanding of the general principles of international law, they make mistakes. Because if you make mistakes, obviously if you make mistakes, particularly if you are working in, I'm sure there are colleagues here from the ministry, etc., when you give a legal advice, you have to be very precise, because it has impact, it goes to international bodies, it goes to other, bilateral meetings where people are aware of what exactly they are doing. So I think that's the reason why I think I agree with Professor Monica Chawla up to a point, but I do not agree with her saying that people are not taking international law, etc. They are taking international law. Only problem is they are actually not aware that, that they have to, they have taken a topic which is international law oriented, but they are not applying the basic principles, they are not examining it. Because today, every topic, even within domestic law, has international legal elements. You take Arbitration Conciliation Act, preamble itself says that we have taken it from UNCITRAL. You take any of the intellectual property, take patents or copyright, trademark, where I am quite familiar with, every one of them actually talk about international law, because amendments have come because of patents. Act has been amended 3 times precisely because of the TRIPS, whatever has happened. Copyrights, if you look at footnotes in copyright law, you will see that the amendments which have been made. So there is a whole problem, not problem really, the dominance of international law on domestic law. And I just mentioned across the road, Supreme Court, last 15-20 years, thanks to my teachers and colleagues and others, I've been examining the Supreme Court quite closely, writing about it. How actually they are looking at or studying international law. In this very podium, one of the Supreme Court judges agreed that they only did international law at the LLB level. After that they didn't. But they have to deal with international law. See, Enrica Lexi, to many of the important cases they have dealt with, they have talked about it. Yeah. So then without, and it is I'm not saying that judges are to be blamed, it is the lawyers who are actually making presentation are to be blamed, because they don't have the first-hand knowledge of international. Let me tell you my personal experience as a desk officer in the ministry. At one point of time, I don't want to mention the name, the Solicitor General didn't know exactly what actually immunity meant in a particular context, why a state cannot be brought before the court. So he asked, who is the desk officer? So he made me sit in front of him, explain to him the nature of jurisdictional immunity, how it works. At least he was very kind enough to do that actually. And there are many in the legal fraternity do not understand these basics. The immunity or jurisdiction or how it works, even in investment arbitrations. Let me tell you on investment, because I have lived with all my investment friends. I shared a room with one of the celebrated investment writers and colleague for many years. Room in the sense we were same colleagues, and discussed this issue quite a lot. And I said, you cannot only quote, you look at Swarna Raja writing, you have Subedi writing, there are many authors you must read actually. Swarna Raja of course is a great critic, there are number of, but problem is, I said I read many of these judgments or tribunals, except ones which Professor Chimney did a great work on exit arbitration, we did. He made me read as well. So we realized that there is a problem there, because they are giving interpretation. Today we are saying this whole bunch of international legal law, international arbitral tribunal lawyers come out with certain interpretation and say this is how it's going to work. States are not going to accept it. This we said way back in 2010. And India decided to go ahead and decided to get away out of 85, suspended it. This was anyway coming actually. Because you look at finally, what happened. I would rather tell them, go and look at the work, and matter was taken to the Institute of International Law, Institute Dhruva International started discussing this. People should know this actually. Professor Monica Chawla, 1 minute. Institute Dhruva International decided to take up this matter on investment law precisely because there is a problem of interpretation. Problem of interpretation by few of the, our so-called arbitral tribunals and then arbitrators, and they came out with all kinds of, you look at the interpretation, there are quite many. So I am a critic of those things. So now we need to have a proper, so we have a disciplinary boundary, okay? We are here, this is, I'm going to just finish it in the next 2-3 minutes. We are within a disciplinary boundary called international. So we need to sit in that boundary and decide what we want to do. See, now what is happening is, these boundaries in our law schools, in our universities are now being breached without knowing that, if you look at international lawyers of our earlier era, I'm sure many of you know. I want to say whether it is from Madras, starting from Alexandrovich or Madras University or Andhra, you have great B.S. Murthy and all these people. Look at the article written by Professor B.S. Murthy in Max Sorensen's book. Even today, that's the best piece on dispute settlement. Look at the most basic thing. That's a textbook Max Sorensen gives you and B.S. Murthy wrote about it. So how many of us read these things? And it's an old article. It's almost 40-50 years. But he wrote, and there are many writings, of course, within our Indian Journal of International Law. They dealt with some of the most basic aspects of international law, including history, including, if you want to look at 1971 war, legality of 1971 war, only article you have is Professor Mani in Indian chapter. Just go there. So you need to, how do you actually analyze Ukraine-Russia war? Just go there and see what Professor Mani has written. Or there is a basic understanding of how to look at things actually. That's the problem, because lack of this basics. In many of the law schools, I remember my own law school when they decided to change, they taught us excellent general principles of international. I'm not talking about JNU before I come in. There they called me and said they want to now change it because, as Professor Monica Chawla mentioned, nobody is interested in international law, so we want to make it called international business law and commercial law. Then I requested them, please don't take out the general principles at any cost. Keep one course or 2 courses on general principles of international law. Now, and then teach international business law and commercial law, because they will, if you directly teach international business law and commercial law and intellectual property rights without telling them what is actually general principles, they will make interpretative mistakes. And that is what exactly is happening now. Now, let me tell you and end my talk by saying, what are the basics in international? Now we are talking about basics in international law. The first is nature and definition. I am talking about very simple things. Nature and definition of international law, including, now nature and definition of international law has changed in the last 30-40 years. It includes private international law, it includes trade law, economic law, you name it, commercial law. At one point of time, when we were talking to Supreme Court judges, we said anything which includes a foreign element, legal element, that's international. Anything, including, it is not just the private international law, what Professor Monica Chawla talked about personal laws, but private international also talk about contracts, it also talks about citers, and also, yes, many things. So, there you have foreign elements which are coming in, they are all international. So, definition and nature of international has changed considerably. But basics have not changed. Basics, you need to know the basics. In law schools, problem is many of them do not actually understand the basics. Second point is state and sovereignty, changing nature of this. All my colleagues and young friends have mentioned it. Professor Nilendra Kumarji also mentioned it. State and sovereignty has to be understood properly. Sovereignty is something which, without understanding sovereignty, how it works, you can't explain Russia, Ukraine. You can't explain Kosovo. You can't explain anything, including if you read ICJ judgments, you can't explain. If you read ICJ, please read the judgments very carefully, including the advisory opinions. You cannot understand how a state functions, sovereignty, nature of sovereignty. Some of them are great international lawyers. And let me tell you, when Professor Anthony Angie, I met him, several times, but he took up a research. He did his PhD on imperialism in the 90s. or late 80s, I took up a topic which is so irrelevant we all thought. I mean, I thought, at least, I was much younger to him. But imperialism, the way he built it up, and there is a whole scheme of things which have come up actually. So no topic is irrelevant in that sense. Even today it matters actually, in case if you are negotiating international conventions, whether it's biodiversity, climate change, or the WTO, these days dispute settlement mechanism, appellate body problems, and Trump, and then Biden continuing the same thing. The problem in Africa, just yesterday or day before, the military coup in Gabon, and then earlier, just all these problems, Niger, I don't think many of us don't look at Africa. What is happening in Russia and Ukraine, you should also look at the territorial acquisitions made by some countries, and then nothing has been said by the US administration. They are talking about Ukraine, but there are areas where, the Polisarias are still fighting in Africa after the territorial acquisition by the Morocco, and none of us are looking at it, and and there is a total sort of a dichotomy exists in the US foreign policy. How do you understand this? And how do you put international law? So, nature of international law is important, state and sovereignty, identifying sources of international law. I don't want to get into this complex, most complex issue, and across the road is always a problem. They have not understood it. I am sorry to say, in sitting here, they have made mistakes in their judgments. I can tell you, I told them also in many occasions that there is a whole problem in calling a principle or even something customary international law without knowing. This is the lack of understanding of the lawyers actually, without knowing exactly what actually is, many of them of course do come here. So sources of international law continue to be a very big problem, because see, only in Vishaka I think Judge Verma came out with an excellent judgment because of the lack of, because Supreme Court will have to rely on international. Because when there is in international there is a word liquet, there is no liquet, then you need to, when there is no law on the subject, then this is globally done actually. The Lord Denning said this in 1977 itself, when he had to decide a case, that I am going to rely on international law, but he has to arrive at certain, and international law is binding, and which is a binding international law. So that is exactly what our courts will have to understand. Otherwise what happens is you quote something, and these days judgments go all over the world, so that's another one. So let me quickly say, implementation is another area where implementing municipal law, the international law interface is something which is already many of them have said, and we don't understand it actually. And if you ask the law school student, can you tell me how international is implemented? None of them know Article 253. None of them know Article 246. None of them know about the configuration in our own constitution. We say constitution, where does it come from? So nobody knows. I tell you, law school, Professor Monica Chawla should know this, and they are working on some of the most important work on refugees. We are talking about CAA, we are talking about all this. None of them know how actually international is implemented in India. Actually. And I am telling you out of my experience. And then sources, municipal law, jurisdiction and procedural issues, I have already said. National security exception, public order, public interest, this is the most important area. This is the most important. How do you define this? We have a, when you say even in investment arbitrations, there is an age-old decision, even internationally accepted, public interest, national security. There is Article 21 in GATT, which is national security exception. You can throw away anything. If a state, you have a this legality of nuclear weapons advisory opinion by the ICJ, which says that if a state's hands are tied, it can do anything actually, including use nuclear weapons. Despite the great legal opinion given by the Viramantri, which you should read. But the court has to say that, okay, they couldn't say, they can't prohibit war. So obviously they can regulate war. This use of force is another, I don't know, the language of international law, enforcement and compliance, there are so many basic things which I am sure many of our young friends should know. I mean that's what I say. And then pragmatic approach and clear legal reasoning is necessary. And of course, we all use the same legal reasoning, and we all come from the same law background, but need to teach general principles of international law so that mistakes are not made in dealing with above mentioned issues. And last point I really say, which Priyanka mentioned, I just like it because it's not the librarian who is going to tell you what actually you are going to take actually recourse to in disciplinary boundaries. It is you. When you prepare your, this is what in our context in where we said first you go and find out which are the journals you have to read first. You have to identify, if you are in a disciplinary area, I'll say Indian Journal of International Law. This is my regular thing, American Journal of International Law, European Journal of International Law, Asian Journal of International Law, Chinese, you read Leiden Journal, you read 6 or 8 journals must. I tell our students, first go and see these journals, you find something, and then if you don't find any, because these are the journals which are age-old journals, they use the language of international. Now there are numerous journals in digital form, so you can just go. I have seen theses which I didn't understand. There are all kinds of, URLs, and I have not heard of them, and then you quote them. How do you quote without contexting properly your ideas? Look at some of the best works which are done in various these journals. You have to really understand your disciplinary boundaries and look at it. At any given day, these are the 6, or there can be many now. There are many good journals I might have. Definitely, certainly American and Indian, Asian, Chinese, Leiden, I think they are quite represented. Even Sri Lanka also has a yearbook. This is the yearbook of the Asian Yearbook of International Law. There are a number of them. And I am telling you, we have met people in various conferences in international law, abroad, here and there. We all speak the same language. I understand them very quickly, I can tell you. Whether here I hear my gurus here, or Dr. Pierce Rao, or I hear Porters, I hear Reisman who came here, or I hear Brownlee who came here at one point of time. All of them, if they speak in international law language, I understand them. Richard Falk also I have heard online, met him. Here, he came here also. It is easy to understand. If you are in design, it's like in the same league actually. I am telling you, language of international law is no question. Whoever has done 20 years, 30 years, read this journal, you will be in a comfortable, you will not feel out of. Edith Brown-Weiss came here. Many of them came here, all the celebrated ones. They speak on, she was a great environmental lawyer. It's easy to understand. They are all here. ISIL is the premises where if you speak, you will understand. And last really one point is the Priyanka mentioned, I agree with her actually, but digital technology doesn't mean that you need to ask librarian. It is you who will have to first go and see, and then librarian can't make it out. Librarians are not trained to actually do these things. They can only give you if you ask them, but when you actually decide your areas of research, you need to decide what actually you have to read first. At least 10 seminal articles, this is what I always keep saying to the students, at least 10 seminal articles in the area that are path-breaking, that is important, that you should read, and if possible available, books, 3 or 4 books, starting actually, of the area in case. That is how you should actually plan your research. So, it's not happening, I mean, I am telling you. In the law schools, I mean, I have said this, and many of them are dealing with international law, but we need to do that as Indian Society of International Law. It's our responsibility to push this agenda to students to take up, because I agree with again Professor Monica Chawla again. There, of course, also with Milendra ji, that there are some IHL courses, some law and justice course, some human rights course, but core course in international law is required. General principles should be required. Only National Law School, I am sure here is my colleague is here, is teaching, but there must be made compulsory. They must know exactly what Madras did, what fabulous works have been done. I can tell you in India, we need to know, and Delhi University, of course. Some of the greatest scholars were here, and we forget them. Of course, ISIL, we are sitting here, which is like a synthesis of all. They all came here. They all came to Indian Law Institute. So I think that's one of the hopefully I think we also should know our peers. So we need to be passionate about it. So that is what I always talked about. So that's why when I say come to basics, So basics in all forms. So we should be that actually. So with that, thank you very much. Sorry for taking more time.
Thank you.
Mr. Chairperson, since I have to, since Mr. Hegde has put in some questions, just 2 minutes I will clarify my point here, because I need to really put in my words. I think it's been misunderstood there, where though he in the end has agreed to what I have said though. The point I still say is, he himself has endorsed, Mr. Hegde himself has endorsed that people do not know what is international law. That is what my concern is, that in the universities, we are not able, students are not showing any interest to take up international law as a specialization. And this matters to me a lot. Students want to take cyber law, artificial intelligence, LLM in cyber law, artificial intelligence, criminal law, even many traditional subjects. My concern is very genuine, and a very simple words that I have put in, that international law does not interest the students in the traditional university or NLUs, so we are not able to create good international law students. If we do not have good international law students, how do we actually take people up in the ministries or other places if we do not have those students around? I don't know in what way you have interpreted it. My concern is very simple. I do not find many international law exclusively international, because it's a very, very tough and a very vast subject. So students do not take that up. That's only, and as far as private international law is concerned, as you said, I'm carrying the banner of Mrs. Jimbote. Now, just in that way, marriage, divorce, I have in my paper mentioned that law of contract, law of torts, contracts, all these things are covered under the private international law. It is again a very vast subject. But why we do not find students coming to the diploma in private international law in the ISIL? Now this in itself shows concern that they do not actually want to come into this field. This concern will always stay, since the society is basically for dissemination of international law. So my concern, I do not need much of the knowledge of the subject, but this is a very simple thing, that yes, we do not have LLM of international law in many of the universities. Even in the national law schools, if there are 29 international law schools, you can check out how many of them are catering to the specialization in international law. They are catering to corporate laws. They are exclusively made for students to have come up with corporate knowledge, to deal with the industrial-based system. As one of the panelists has said, that we are shifting from knowledge-based education to catering-based education. Why this? This is what I really wanted to emphasize on, that look into the fact why the students are not actually taking up. If the students are not taking up international, then how do we have good teachers? You and me are already on the pedestal, or more than half days gone, but I do not find many. The senior teachers are there who put in all their lives to bring the subject up at such a pedestal.
Your point is
this is my concern. Rest all, I'm really sorry if I put in anything. I've not been able to extend my view properly.
Any comment?
No, I totally agree with Professor Monica Chawla. No difference on that. But only point I am saying to Professor Chawla is that they are actually taking international law. If they are taking cyber security, AI, all this, they have to eventually look at international conventions and things like that. And without knowing how to interpret, they can't do it actually. They make mistakes. And in case somebody,
matter of concern,
including corporate law, you are talking about corporate law. We have students in JNU from earlier times who are working on business, international business transactions. Now somebody is working on corporate, he is in the corporate ministry only. He's working on the, what is that topic on cross-border insolvency and then the new port. But all of them have international elements. So obviously what I am trying to impress on law schools is they must have a course where they can interact with the topic which is extremely cutting edge, but at the same time knowing the basics of international. So this is what I am saying. But I am totally with you on this, Professor Chawla. No problem.
Thank you.
I think we should be, sorry.
That's right. Today, Dr. Rangreddy sir wants to make an observation.
Thank you. I generally don't talk. Slightly compelled to support Professor Hegde. Although I am from the government and I deal with the practitioner side of international law, I think it is wrong to shoot the messenger. I think you should not blame the students. I have taught for some few years in the South Asian University, and I think it is, if students are not coming to the field of international law, I think it's time teachers start inspecting as to why they are not coming. There's a very famous book written by Judge Manfred Law called as Teachings in International Law. The title actually is Teachers in International Law with a bracket, teaching and teachings. And if you read that, we were taught in JNU these things. Professor Anand used to always speak about this, that how international law should be taught is something which maybe not all law schools and universities really take up. But I would not agree that students are not craving for the subject. I remember, I will not take that teacher's name, when I was doing my symbiosis, my LLB, there was only one book that teacher had. And that book, I could see that it is completely torn and tattered. And I could see that he used to refer the same book for years together, and I met him after 25 years, that same book he had with him. So if somebody has to be blamed, I think it is the teacher. Don't really shoot the student. And if at all, like in JNU, I can give examples. Not only there is a multidisciplinary approach there, but it's a very strong combination of teaching and research. It's teachers teach, but at the same time they inculcate ideas in the student to take up serious research. I think it's a fascinating Professor Hegde and Priyansha and Sudhir and Major General Verma. I think it's a very good topic of discussion. Maybe next time I'll participate in this session. It is important to I think teach students, and it's also important to make them understand. Maybe their law schools are not the best equipped because they have a very strong course curriculum to finish their LLB. The time is less. Maybe there can be international law departments that take up serious teaching and research. Maybe law schools don't have an advanced international law department. But I remember I used to work as a deputy collector in Maharashtra services. Where I resigned my job and went to do my LLM. There was 4 papers of public international law and 2 papers of private international law for my LLM. There was no teacher in private international law. But there were 5 students we had. This was way back in 1989. And that one teacher used to come and we used to attend that private international law class. There's only one book of Cheshire, Ambedkar Library there, and one book of Paras Diwan. And somebody had torn pages of that. So we used to go to Mumbai to get those things photocopied and come in 89 so that we can study. So I really don't blame the teachers, the students. The teachers have to take I think equal responsibility if international law is not fascinating enough. But I think times have changed.
Thank you, Rangreddy sir. Now e-books are available and many digital platforms are available. Yes.
Thank you, sir. I am Dr. Banerjee and working with VITP School of Law. In fact, it's only observation. That observation is that today we are talking about so many issues of international law teaching. In fact, in India, it is more happenings are going on from the international law perspective. We'll take an example. Supreme Court last 1 week they have been dealing with Article 370 abrogation. And we have a CAA, we have NRC, then followed by, now ISRO has sent Pragyan Rover to the moon. But none of our international students or none of our international faculty dare to write anything of international law, because we are all re-christened and re-baptized ourselves into the nationalism. Okay, we are not talking about international law, that's the main problem. And the state want to take the mantle of international law, but the state is conveniently putting that into garb of nationalism and jingoism. So that's the main problem of international law today in India. That is why we are not able to find the relevance of international law today in our teachings. Like what all the speakers are speaking about, that if it is a commercial law, if it is a business law, if it is any subject you take today, there is no relevance of teachers entering into the classroom and saying that okay, this is not part of international law, it is only commercial law. That's the main perception of the teachers. We have to change what our Professor Dr. Luther has mentioned. The second thing is that, the second observation, that in international law today people are saying that far-flung people are not able to take up. Let me take example of northeast of India. Every university has got international department. Particularly I can tell you that Department of International Law and Relations with the Guwahati universities, until recent past they have 14 professors working on international law. Can you imagine anything? And one particular professor, Sanjova, who was passed, and he was an ardent supporter of humanitarian law. He has gone on his own money, travelled across entire Northeast, distributed in IHL copies. That is what the kind of people we have, but mainstream we don't recognize them. That's the one problem with us in international law. The second problem is that dissemination of IHL, what Major General Nilendra Kumar was talking about it. In fact, in India we have 1274 law schools are there, precise number, out of which BCI has recognized 769. Out of 1274, 769 have been recognized. Out of 769, you can Google it and you can find all the statistics. There are 500 plus universities offering international law as a compulsory paper. And international humanitarian law is compulsory in some universities, and some universities as a part of optional paper. Apart from that, there are other departments like PG departments in the various public universities, both center and state universities. They are offering as a part of international relations, international humanitarian law, refugee law and human rights. And I can give the credit to the ICRC. They have conducted several rounds of All India Vice Chancellors Conference with the UGC, and they made got approved to introduce this discipline long back. It was way back in 2004. Now we have been 20 years disseminating. Even our own ISIL conducts international humanitarian Henry Junon Memorial Moot Court competition. When it started in 2002, only 3 teams were participated, and in 2008 and 9, 89 teams were participated. Vinay is there, he is a witness to that. Till today, international humanitarian law has become the religion of a lot of law schools. The only problem is that teachers. We don't acknowledge. And every international law teacher goes to the mainstream law school saying that international is not a law. They teach the same nonsense and nuisance. Now, that is why I am giving a kind of unilateral mandate to our ISIL that at least we need to come out with teaching and research in international law. A cogent and a small book which we need to disseminate and send it to all the law schools. Ask the teachers not to teach. When you are talking about the nature and scope of international law, first they put all these books into dustbin. Start with R.P. Anand, New State and International Law, and let us teach international law. That is how we need to teach them. This is what's happening. But today, because of the political climate, we are now keeping every international aspect under the carpet as if we are newly born. we are trying to find that, internationalism today only started. Because everything for the first time is happening as if it's not true. We need to go back, we need to trace the history, like what Professor Hegde sir has mentioned. We have the best centers of international across the country. And when we were studying, and Professor Dharam Pratap book and Shabda Erosion was read together with regard to the procedure of international law concern, and B.S. Murthy's book has been read compulsory thing. And today, if you go to any of these centers in international law, they are reading, but only people is that they are not able to come to the mainstream. That is the only problem, but we need to recognize. So that is why we need to take this as a kind of religion, and we need to spread the word and steer the students, those who are coming to international stream. Last thing is that today I was very happy to see that there are 25 students, those who are actively reading international law. They all have come from SCIU, from DU, from JNU, Symbiosis students are here. Like that there are many. Don't tell us these kind of lies to them, and the same legal positivism is proposed, like my colleague and Sudhir has already said. We need to teach the new perceptions of international law that should start from our ISIL. Thank you very much.
Thank you, Dr. Banerjee. Any other person who wants to ask any question or make an observation? Okay.
I would respond to what Professor Hegde said and my friend Professor Chakka Banerjee said. I'm in agreement to a lot with them. But having said that, I find it difficulty. Number one, I will talk about IHL and then I will go to law in general. In IHL, yes, Henry Dunant is taking place, and it has over the years come to find greater acceptance, the number of teams. But so are the moods in other subjects. But what I find it surprising that there are moods relating to corporate, relating to arbitration, relating to IHL, etc. Going to the basics, what Professor Hegde said, why is it that no mock trials take place? Because these moods have something similar to what the student has done earlier at 10+2 stage in the form of debates. But the basics we are talking about, examination, re-examination, cross-examination of a witness, which is a lawyer's job. Because after all, a law professional, whatever he may choose to do later in his career, this LLB becomes a suffix to you. You are expected to know the basic law. And this basic law is not being taught in the law school. I am referring to, say for example, CPC, CRPC and Indian Evidence Act. How is a document to be produced? Evidence of a child witness, is it permissible? In that sense, perhaps holding or the greater attraction of Henry Dunant has really not resulted in interest in IHL. But then linked to that is not with the international law alone, but all other law subjects. I find, I was there, I'm not from an academic world per se, till I landed up with the Amity University, and there I was there for 7.5 years, and from third day I started teaching. And I took up those subjects which no other faculty had taken up in the 9th semester till then. Anyway, that's not what I want to talk here. It is the faculty which needs to adopt a clinical approach which is absent today. You would find a very harsh reality that a faculty who's teaching CRPC has perhaps never seen an FIR, has never been inside a police station. The faculty teaching taxation can't fill his or her own tax return. Now, this situation is to be changed, number one. Linked with this is the advice to the students with regard to their career. Now we take pride in saying that the 5 years or the 3 years degree is a professional degree. But really, do we equip them to enter the profession? How much time does it take after a person gets a law degree to get into a trial court independently? Or say even in a corporate law firm? And viewed from that extent, I would say that there is need for a mindset and a change in the capacity of the teaching faculty, and that would travel down even to the field of international law. Thanks for your patience.
Thank you. I think we are coming to close now. If there is any, you want to make any observation?
Just one observation. I mean, it would be a sort of a repetition with what Professor Banerjee has said. Just one observation which I always tell to all my students in all my class is that there are no bad students, there are only bad teachers. उनका कोई गलती नहीं है, गलती टीचरों का ही है. That's all.
Okay.
That's it.
Thank you. If there is okay, friends, as a chairman, I would like to share a few thoughts and have last words of this session. All the panelists and all those who intervened from this side, from the audience side, highlighted the importance of international law teaching, highlighted the problems of lack of interest among students to take up these courses. I slightly differ, from this approach. Not only students should be taught about international law, even the teachers should be taught about international law. I have two suggestions. One, because of many cases filed in the Supreme Court by M.C. Mehta, Supreme Court gave a judgment that teaching of environmental studies is compulsory in India at the graduate level. Like that, I think ISIL also can advocate that teaching of basics of principles of international law, which Professor Hegde summarized. You don't have to teach 1000 pages of Malcolm Shaw's textbook of international law. I was doing PhD in JNU on international human rights law, and my own teachers never asked me to do a course on international law. Very surprising. And I had to, when I did my LLM in England, Malcolm Shaw was my teacher, and I was asked to do the course because I had never done any course in India in international law. Now, I suggest that ISIL, Indian Society of International Law, should take up this cause of how to make teaching basic principles of international law to general public, to students, all the graduate students in India. And also, I think we should think of having an online course for teachers, like you have the courses here for regular students, evening courses. This Academy of International Law of ISIL can think of starting a course on basics, principles of international law, which Professor Hegde talked about. A module can be designed, a book can be designed, as Professor Banerjee said, a small book should be prepared. In all the, later it can be translated in all the 22 languages of 8th schedule. It's a long project. The society should think about that. Because my approach is that international law should be taught to every student. International humanitarian law should be taught to every student. International human rights law should be taught to every student of India, irrespective of any discipline which we are pursuing. Because now India is standing at a place where there is a risk of, producing mediocres. This new or national education policy 2020 has abolished MA. There is no need of doing MA now. After 4 years graduation, you can directly go for PhD. MPhil has been abolished. I don't know whether JNU has abolished. MPhil has been abolished. You will not read, earlier we used to read Britannica, Encyclopedia, etc. Now people are reading only Wikipedia, which is not authentic. So we in the society should think seriously how to disseminate knowledge about international law, international humanitarian law. A good researcher can be a good teacher, and a good teacher only can be a good researcher. Both should be combined. I think with these few words, I thank all the 5 panelists, Major General Nilendra Kumarji, Executive President ISIL, Professor Hegdeji, Monica Chawlaji, Sudhir Vermaji, and Priyansha Badoniji for sharing their thoughts, their experiences and their insights, and educating us about various aspects of international law. Thank you very much. I thank the ISIL for giving me this opportunity to chair this session. Thank you all.
We thank the chair also. Yeah. He is one of the senior members of the ISIL.
Hello.